to introduce Allison Hertz again from our Palm Beach Gardens office. The floor is yours.
Okay, thank you, Jeff. Thank you for everyone for attending today. As Jeff mentioned, this is a follow-up to the October 28th course on elections. I'm Allison Hertz from KBR's Palm Beach Gardens office. As Jeff mentioned, once again, I am board certified in condo and plan development law, a specialist by the Florida Bar. You know that this is what I do. I'm very into election issues, and I find this topic very interesting. And it seems that a lot of the clients and who I work with and in my experience have a lot of questions here, and some of the questions are very important to get answered leading up to election season. If you have any very specific questions, you may have realized that I was not able to incorporate them into the presentation today, but for those of you who followed directions and kept your questions brief and allowed for me to respond to them generally without trying to give legal advice specific to you, that's not what we're here today. We're here to give general information regarding elections and try to answer these general questions as best as possible. They do come up all the time, from time to time, every year. So let's get this thing rolling. I'm going to start sharing a PowerPoint where I took all of your questions that you submitted and I broke them down into specific topics. So we'll have a topic, and then we will talk about all of the questions that I could get to related to that topic. And Jeff will be scanning some of the questions that were submitted when you registered for this course, and maybe the ones that have been submitted today, and maybe he'll throw a couple more questions out there. As you know from my course last week, these election issues are very specific concerning whether you're a condo or co-op. They pretty much have the same laws, or whether you're a homeowners association. If you're associated with a homeowners association, the election procedure for your association must be conducted in accordance with your governing documents. It's a very specific governing document type of matter. I can answer these questions generally speaking, but you'll hear me from time to time. I always say, this is a governing document specific issue. You need to get with your attorney on that issue, figure out what your governing documents say, and whether your governing documents might need some changes to get you where you want to be. All right, so I'm going to share screen, and I'm getting pretty good at this, I think. You're on the right one, Jeff?
Correct. Yeah, we're looking
good.
Yeah.
All right, so here we are with our follow-up course. The first slide or topics that we'll get into are regarding, the date and time and place of the annual meeting, when this has to occur. There were some questions here, and this is important. You have to start off getting it correct here. So some of the questions we got, and I did not edit the questions. I corrected typos here and there, but these really are your questions that are verbatim submitted from last week's course. So I'm going to read the question and we'll talk about it. We'll talk about the applicable law, and we'll get on to the next question because we do have quite a lot today. I have an HOA that's been having their annual meeting in March when the documents say December. Can they have it in December this year, or is it more complicated than that? Well, the law is pretty specific here that you have your election on the date of your annual meeting, unless otherwise provided for homeowners associations. So if you have terms of directors that are coming up, that they're not serving out a 2-year term where an election isn't required, but terms are coming up, you are supposed to have the election on the date of the annual meeting. And the fact is that just because you may have done this incorrectly or inadvertently not complied in the past doesn't mean you should continue on with not complying. I think the better answer here is to frankly hold it on the date that you're required to do so under your governing documents. That is what the case law provides, that you have to hold it on that date. So I think it is not that complicated, and you follow your documents and you start getting back on track is what I'll call it.
Well, it's not complicated, but what happens spawns a question here. What happens? Is there a penalty if you don't have your annual meeting or election? What can the penalties be? Would it take somebody having to report the board?
Well, from a homeowners association perspective, you don't have a state agency like the Division of Florida Condominiums overseeing your elections. So in a homeowners association, it would be quite difficult. You'd have to send a demand for them to participate in pre-suit mediation or file some kind of lawsuit or election challenge with the division and take some kind of more formal action to somewhat call them on it. If you're a condominium association, you have the opportunity to make a complaint with the division, and the division might investigate this and at least write to the association
Yeah.
and give them a letter saying that you have to comply and possibly fine them or, get on their backs a little bit. As a homeowners association, it's a double-edged sword. You don't have as much regulation, but you don't have an agency to go to complain
Yeah.
to about these kind of matters.
Okay.
What is the required notice period to residents to set an annual meeting date? Next question. For a condominium association, this is pretty clear in the statute that you have to send a first notice of election. So it's not the notice of annual meeting, it's a notice of election 60 days in advance. That's your first notice. Then for a condo and co-op, once again, the second notice, which is actually the notice of the annual meeting, must be sent no less than 14 days in advance or such other longer period that your documents may require. Sometimes the second notice for condos has to be sent out 30 days in advance because your documents require it to be sent out longer than the typical 14-day period. For a homeowners association, it's whatever is provided in your governing documents, and if nothing is provided, it's a 14-day notice. I frankly think that for a homeowners association, even if your documents allow you to send notices on, a 10-day or a 5-day, which I have seen before, it's a way too short to get, any good response, and it's much more responsible to send it out 14 days, in my opinion.
Okay.
Next question. Jeff, you have anything there?
It's sort of related, but not quite exactly. And it has to do with an HOA and a board member filling vacancies, which may come about in midterm when it's not for an annual midterm. So if an HOA board decides to fill a vacancy or vacancies, which come about midterm, does that have to occur during a posted board of directors meeting at which a quorum is lacking due to the vacancy, or can the lone remaining board member make appointments on his or her own to fill the vacancies outside of a board meeting? Again, not quite related. But
Yeah. This is not related. We have a topic on vacancies towards the end of the presentation, but just to get through this answer right now, no, you cannot take that action outside of a board meeting in order to appoint directors to the board. You have to take action at a board meeting or frankly ratify it after the fact, and obviously it has to be documented in the minutes somewhere.
Okay.
So that's the key thing that you want to get with that. And speaking of minutes, the next bullet point here on this slide is somewhat related to records, minutes. They want to know regarding how you send notices, via email. What about email? Can't we send the first notice or the notice of the meeting via email if owners have consented to receive notice in that manner? And yeah, that is true. If you have owners who have consented to receive notice of meetings via email in lieu of by mail, which definitely cuts down on a lot of costs here, you can do that. And then the question here, really the key is that in that case, wouldn't the email addresses be accessible to all other members? And this person must have watched one of our other courses or just studied the statute or knows their stuff, right? Because this is actually correct. And I say this all the time in my board certification courses that this is allowed. You can have notice via email, but if you as a board member or resident opt in to get notice via email, the email address that you use becomes an official record of the association, which is accessible to other members. So what I say here is that if you want to do this, because many of us want to just get emails, that you might want to create another email address for this purpose or use some other, secondary email address such that, you are understanding that the association has to give this email address out upon request of a member. And that could be used by the member in their plate to the board and, sending out political messages or, in whatever other manner. So that's typically how we see it here, that, somebody who wants to be a candidate for the board or who's already submitted then gets this email address list and then sends emails regarding their platform. And a lot of boards have, members have asked me through my legal career, is that okay? Are you allowed to send messages regarding your platform? And it's politics. I don't think that there's anything that prevents that other than maybe something in your governing documents, which is, possibly or, may or may not be enforceable. I'll leave it at that.
And if you are receiving emails, remember if you consented to receive emails, it is your responsibility to make sure that you check your spam filters and such. It's just be sure that that's something you're aware of too.
And that is actually added to the statute, that the association is not responsible for any kind of spam bypass filters which prevent you from receiving the notices. Last bullet point on the slide about annual meetings and the election date notices. If a board meeting is going to be held via Zoom, does the Zoom meeting login information need to be on the agenda? Okay, we'll just talk about all meetings. So for the first notice of the election date for a condo, no, the Zoom meeting login would not have to be on the first notice. But for any other meeting notice for your association, your second notice of meeting, a board meeting notice, your organizational board meeting notice, if you're going to have a hybrid meeting, because I don't believe you can have virtual only meetings at this point, but if you're going to allow people to attend by Zoom, which we talk about throughout the presentation as we get to certain other topics, yes, I do believe you need to have the Zoom login information right there on the notice and not somehow sent afterwards or sent by email or sent in some other manner. I think it has to be right there. And we prepare many notices for clients, day after day after day here in the office. And I'm constantly asking managers and board members, please send me the Zoom login information, or I leave a blank space on my form notice that I'm preparing for them and instruct them that it must be on every notice except that first notice of the date of the election for condos. Okay, the next topic getting into is eligibility for the board. I find that this really is, one of the topics that we receive the most questions on leading up to election season. And I can't stress enough that, going back to the HOA issue, which is not really related to eligibility, but you have to follow the election procedure in your governing documents for a homeowners association. Don't just assume that you have a process that's the same as condos because that's what you've used year after year after year. That if you do not follow that process, your election will be jeopardized, and you just want to do it right the first time. So if you're questioning what your process is for a homeowners association, this is the time to look into it. Eligibility for the board. For a condo, once again, and a co-op, the law provides that you must submit your notice of intent to be a candidate no less than 40 days before the date of the election meeting. For a homeowners association, there is no law regarding how you submit a notice of intent other than you're authorized to nominate yourself from the floor of the meeting if there's no pre-nomination procedure. But let's just stick with this. For a condo, you have to notify the association in writing of your notice that you want to be a candidate for the board at least 40 days in advance. The question here is, can a time like 5 p.m. be put on a deadline, or is it just any time that day? Well, the law says that you're entitled to submit it on the 40th day. So I do not believe that you can put a deadline like 5 p.m. or, close of business when manager leaves office on your notice. That is not going to be valid. However, I will also say that it is on the candidate to ensure that they have proof of delivery. So it works both ways here. You can't put a deadline on it, but the candidate also has to be able to prove that they submitted it that day. So in order to do that at, 11 p.m. that night, maybe the candidate faxes it in and gets some kind of fax confirmation page if you still have a fax and the candidate has access to that number. or maybe they have some kind of, email that they send with one of those read receipts. These are not the preferred method to be submitting a notice of intent. By the way, if you're a candidate out there, you probably want to submit it by certified mail or some other proof of delivery method. I will say that the Florida Administrative Code is very detailed. If you submit a notice of intent by hand delivery, you go to the office manager in her office and you say, oh, here's my notice. The code actually requires you to get a receipt in that case because there is no other proof of delivery. So you could also personally deliver it, in which case you're entitled to a receipt. I also don't think it's a bad idea for association boards, managers to just give everybody a receipt. That if you get somebody's notice of intent in an email, later that reply to the email, say we got it, tell these people that you received it. But that is the state of the law. Eligibility for the board, continuing on. Our documents say a member of the board must be a full-time resident. Is this valid? No, that is not a valid provision of your documents. The Florida law says all members of the association are eligible to be candidates for the board. So that is the threshold issue. All members are eligible, and you're not allowed to put other eligibility requirements on top of what is in the statute. So all members are eligible, and the other eligibility requirements are for a condo, you can't be delinquent in an assessment, you can't be a convicted felon with rights that haven't been restored for at least 5 years as of the date you submit, as of the end of the notice of intent period. You can't be removed by the division, but those are the most typical that come up. You can't be a delinquent and you can't be a felon. Issues regarding residency are not in the statute, then they're not requirements and they're just not valid.
I think some people confuse that with having board members that just don't seem to be active and not doing much for the community. So that's why that question comes up a lot. They may tend to use that this person's never here, but it's in reality, more often than not, from what I found in my managerial experience, I'm not an attorney, Allison's the attorney, is that you get a lot of board members that are on the board and then they don't do anything. So maybe that's where that question is born from as well.
Well, I'm sure that was the genesis of the requirements, and I've seen this a lot in older documents. And also, those provisions, if you miss more than 3 consecutive meetings, you're deemed to have abandoned your office on the board. I don't think that's valid for similar reasons. The statute just doesn't support that. I will say that you could possibly get around this by having your documents amended to say that certain officer positions have eligibility requirements, that there's nothing in the statute that says, all members are eligible to be officers. So it's pushing the envelope a little bit, but if it's that important to you that the president, for example, or the treasurer is a full-time resident, maybe there's some room in the law to amend your documents to require that, but not related to members of the board generally.
Okay.
Eligibility issues. Last time we were here last Thursday, I notified you of a new change in the law regarding condominium associations, that eligibility for the board is only related to assessments now. It used to be that you could not be delinquent in any monetary obligation as of the close of the notice of intent period to have your name on the ballot. That is the state of the law for co-ops and homeowners associations at this point. You cannot be delinquent in any monetary obligation. For condos, it's only assessments. The question here is there a minimum dollar amount owed on an assessment to make an owner ineligible? The answer to that question is no. They cannot be delinquent at all. They have to have a zero balance in assessments to be eligible to be placed on the ballot. In a homeowners association co-op, once again, it's any monetary obligation, and that means they owe zero. What if somebody is delinquent with fees that were assessed to their account, such as legal fees? For a condo, once again, if it's not an assessment, and you might want to talk to your lawyer on application of payment issues here concerning somebody that had a delinquency and what their payments are applied to and whether they truly are delinquent in an assessment. For homeowners associations, co-ops, if they legitimately owe fees or owe other, fees, fines, other monetary payments, it gives you some room to argue that. Again, it's a zero balance. I will say that it's a little bit confusing, the state of the law, because you have to have zero balance to get on the board, but once you get on the board, you cannot become more than 90 days delinquent. So once you're on the board and you somehow forget, or somehow something bad happens and you then are 90 days delinquent, you're deemed to have abandoned your office. So one is before you get on the board and one is after you get on the board.
Or you ever experience anything where some of these eligibility items are kind of ignored if there aren't, let's say there aren't enough people on the board, they can't get people to sign up to be on the board? Do you ever find where some of these are kind of overlooked or kind of ignored because they can't get anybody to run for the board in the first place? It's kind of one of our questions.
I mean, yes, we've experienced, situations where the communities have had not a lot of participation and people unwilling to serve on the board. But it's not because people are ineligible, really. I've not experienced that. It's just because, the community is well run and everyone thinks everything is good, or there's a lot of unit owners, absentee investors. So some of the questions we'll get to relate to not having enough candidates to have a full board. Let's see, does the board have to vote that the person is not eligible, or is it automatic? So this is a good question. I thought this was a very good question. If you have a situation where Betty submits a notice of intent and the close of the period to submit is, the end of this week, and she doesn't bring herself current by the end of this week, she is not eligible to be on the ballot by operation of law. There's no requirement that you tell her about that. This is not the same thing as suspending voting rights. There's a difference between eligibility for the board and trying to suspend somebody's voting in their capacity as a unit owner. If you're trying to suspend voting rights, that's a different thing. And yes, they have to be advised of the delinquency, and you have to suspend according to the procedures under the statute. And now there's been some new case law developed to question whether that's even authorized unless it's pursuant to the provisions of your documents. So as for eligibility of the board, what we're talking about today, no, that's automatic. No meeting is necessary. It is what it is. How do we know if a candidate has a felony? Can we require background checks? I think you can require background checks, and if you would like to run backgrounds on your candidates before you place them on the ballot, I think that would be legitimate. If you need to get their approval to run the background, I think they would be required to provide it. Typically speaking, you don't need consent to do a criminal background check, but you better check to see exactly what type of search you're going for. But yes, I think you can require background checks and check out the candidates. This comes up. I don't think many associations really do this, but I think it's becoming more prevalent. I will say that, with the constitutional amendment we saw a couple of years back, allowing felons to restore their rights more quickly, we might have this law, not become very relevant at some point in time where, that they already have their right to vote restored, and this could become something different than it is now. But yes, you have the right at this point in time under the current law. Felons who haven't had their civil rights restored for 5 years as of the close of notice of intent are not eligible. You can run background checks. We have a sitting president who is now on his 9th year. He was reelected last year. Does the 8-year board position apply, and does he need to step down? Second question related, is it 8 consecutive years or cumulative years? This question relates to term limits. The Condominium Act was amended a while ago to say you cannot serve for 8 consecutive years unless 2/3 of the owners voting in the election vote for you, or there are not enough people willing to serve. It runs from July 1, 2018. So that is the start of the 8 years, that July 1 date. And it's consecutive years, not cumulative. So there are some loopholes here where you could maybe resign during your 8th year and then seek re-election and sort of do a runaround on this. We will see when this starts to become applicable again, how this is handled, but it is consecutive starting from July 1 of 2018. And that's, I want to say, for condominiums only, the term limit. That is not for co-op associations or homeowners associations, but I think it's instructive onto where those statutes could possibly go.
Hey, before you get to the next question, to that next topic, there is one question that I overlooked. My fault here. When you were talking about eligibility requirements a little bit earlier, you absolutely covered what can be grounds for somebody not running. But when and how, if you do need to remove a board member for not paying assessments, his or her assessments, how does a board go about that? Is there a quick little rundown on the process for that?
Well, if you have board members who are missing meetings and, not actively participating, or for whatever reason, for cause or without cause, a majority of the entire membership of the association can vote to recall them. And that is how you have to remove a board member. You can't, a board cannot remove a board. Membership had to vote to get the board member in. The membership has to vote to get the board member out, unless they, have so much pressure on them that they resign. I've definitely seen that happen. Or they move, they become ineligible, they become more than 90 days delinquent, they are found to have been getting they have a charge of embezzlement, they've been removed by the division, but there is no authority of a board to remove another board member, and the bylaws that try to provide for that would not be supported.
Okay, thank you.
Okay, we had a lot of questions on, what if there's no quorum at our meeting or not enough candidates submit a notice of intent? What do we do? The first question, I like, this is a good question. I really like these questions. Thank you to everyone who submitted them, because I think, a lot of us lawyers, we are all get lost in some of the details a lot. And, I just want to answer some of these questions that you have. Does every election require a 30% live attendance of owners? This could be troublesome with a seasonal condo whereby there are many snowbirds and rental units where owners don't frequent the property. Okay, so let's go through some information here. For a condo association, the statute requires you to send out an absentee ballot. So you definitely don't have to be at the property for a condo association election. Second, for a condo association election, you don't need 30% in attendance. You need at least 20% of the membership to cast a ballot, and it's an absentee ballot. So there are many, many condos that operate basically with everything through the mail. The ballots are returned, and the meeting always occurs. I don't think I've ever seen a condo election not occur by not getting 20% of the ballots, maybe just barely a couple times. So you don't need live attendance, and it's 20% of the ballots submitted. For a homeowners association, again, it's, the process is whatever is called for under your governing documents, and you most likely will need a quorum unless your governing documents set up some absentee ballot method and you have the same number of candidates as there are vacancies. But for a HOA meeting, the quorum can be no greater than 30%. So that is the quorum for an HOA meeting, 30% or less. Second bullet point, we kind of just went over this, but I think it's so important, I'll say it again. I just wanted to confirm a quorum is not required for an election meeting, but not to conduct business for our annual meeting. So I think this question, yes, for the election portion of your meeting, no quorum is required. 20% of the eligible voters have to cast a ballot. In order to get into the other business to be conducted at your annual meeting, approval of minutes, some kind of vote you're taking, maybe you're taking, a reserve vote or an alteration vote, you're amending your documents. For that to occur, you will need a quorum, and that kind of quorum can occur by in person or by proxy. So for a condo meeting, a lot of times you'll have many different documents in your mailer, right? You'll have your absentee election ballot that you'll return in the double envelopes, but you'll also have some kind of proxy form to help establish a quorum at the meeting, because yes, you do need a quorum for other business to be conducted. For a condo association, what happens if not enough candidates run for the board to establish a quorum per the condo documents? So in a condo association, you know you have to submit your notice of intent to be a candidate by the 40th day. That's the deadline. Let's say you have 0 people submit a notice of intent to be a candidate, 0 people. The period closes. I would, in my opinion, that board rolls over and they continue to serve, and suppose unless they resign. If you have a situation where you have a 5-member board and 3 people submit nominations and the period closes, those 3 people would appoint the vacancies unless your documents require something else specific for vacancies. If you have nobody serving on the board to constitute a quorum, that's a problem. That means any member in your community can petition for a receiver to be appointed to run the community for a fee, and that's going to be paid by all of your members. So if you're in a situation where you just have no board, that you're a member and everybody's resigned, or they just went away, they moved, everyone moved out, and it's somewhat of a whole new administration, that could be a situation where you might need to contact legal counsel, but you could just go ahead and renotice an election meeting and see if anybody is willing to serve after they've been told that if nobody serves, then a receiver is going to take over. So that presents some more interesting and complicated questions depending on what's going on, and could present some other complexities depending on exactly the situation there. Okay, I think, did I skip a slide? No. No quorum or not enough candidates for an HOA. Our HOAs did not get enough candidates to require an election. But what happens if we have too few members attend our annual meeting? Well, I would have to know a little bit more about what your governing documents say for your election here. But for HOAs, if you are required to have a quorum to have your election, then you got to have the quorum. If you have a pre-nomination procedure and your bylaws provide for some kind of pre-notice, and you have a situation where 3 persons have submitted a notice for to get on the board, and you have a 5-member board, and therefore you have 2 people, 2 spaces to fill. Those board members will be elected if you have that pre-nomination procedure. If you do not have a pre-nomination procedure and you need a quorum to hold your election, 30% now, then the board will roll over. If you do not get a quorum, that board will roll over for another year. They don't roll over for another 2-year term or 3-year term. They roll over 1 more year. HOA with secret ballot and election. What is the board's obligation to try and reconvene an annual meeting if a quorum is not established the day of the meeting? If a quorum is not established on the day of a meeting, many bylaws for homeowners associations provide that the members in attendance, although potentially less than a quorum, can vote by a majority to continue the meeting until another specific time. This is really not the board's obligation. This happens all the time. Your election is at a membership meeting. The members control the meeting. The members make motions. The board might preside over the meeting, but this is not the board's obligation to call a vote to continue the meeting. That would be a member's obligation to do that. So there is no obligation. This is a bylaw specific issue, really. Some bylaws get pretty specific here, and they'll say, if you do have a motion to continue, that the date of the continued meeting has to be announced at the meeting, or it has to be announced within a certain time period, how you renotice it. So this is something you need to get with legal counsel if you're trying to do this, or if you're dealing with this type of issue. Let me take a little water.
Yes.
Next on our list of questions is the Impartial Election Committee. This is an issue specific to condos and co-ops. We don't have a law concerning who is counting ballots for homeowners associations. Again, I say this all the time, it's a governing document specific issue. Most governing documents would not really address who's authorized to count ballots at the election meeting, but some HOAs have amended their documents or maybe have very specific, unique documents that actually address this. As to condo co-ops, we're talking about now, condos and co-ops, the Impartial Election Committee. This is the committee that handles the election ballots. They're required to check in the ballots and they're required to open the ballots. So that's what we're talking about right now. Should you elect an impartial committee in a board meeting with a 48-hour agenda posted in the community? Yes, actually, if you want to be strict compliance and you want to be technical here, you're appointing a committee to do business for the association. Any action of the board should be accomplished at a board meeting where there's minutes and you have it documented, that this is who the committee is comprised of, and who voted for that action. I will say that very, very typical, it occurs at the meeting that day where the presiding officers of the annual meeting and election will say, we need an election committee to handle these ballots and help open them. Who would like to volunteer? I've never seen an election challenged or really objected to. I've never seen the division do anything for a committee to be appointed in that manner. But yes, whoever wrote this question, yes, technically speaking, that is how you need to comply. Jeff, I see you kind of shaking your head there.
Yeah, when you have one, let's say you have one of these said committees that you're explaining so brilliantly right now, is it legal or permissible to tabulate these votes on a committee level, I suppose, in private, and then announce the winners without revealing the actual number? Can that be done? Does it have to be done in front of the group, or can that be done in a room somewhere?
Okay, so the answer to that is no. The committee is the body required that is handling the ballots. The Florida Admin Code says that the ballots have to be checked in on the day of the election, either earlier in the day at a committee meeting open to all owners, or as the first matter of business at the annual meeting. So the answer to that question is no. It relates to these second and third bullet points. Is the committee required to verify the validity of condo ballots? I, as a manager, have always done this before the annual meeting and election. And then second follow-up, can the manager be on the impartial election committee? I think that I don't think it's proper for the manager to be a committee member, but managers typically oversee this process. The fact is that the manager is the one, physically handling the ballots until they get to the committee. A lot of times they're going to be put in that ballot box and under lock and key and then delivered to the committee either earlier in the day or at the election meeting as the first matter of business. So the manager is not entitled to really tabulate this in advance and call everybody who hasn't submitted a ballot. That's not what the process is supposed to be. But yes, managers are important. We need you because we need you to oversee this process. You're the one who does this every year and knows the check-in list. You know who owns what unit. You're a needed asset in this process because for those associations with many, many, many units, this is very time-consuming process. This takes forever. If you have, hundreds and hundreds of units, and particularly when there's certain buildings, there's many different buildings, so the addresses are complicated. You need to have a really good sign-in sheet with, the right information, and your manager really becomes critical at that time. I think that's why the code says that you can have this meeting earlier in the day, because sometimes the check-in process takes like hours. I'm at meetings a lot. People get very frustrated when I'm working with the committee and we're doing our best. We don't, I don't want to be there for hours. Nobody wants to be there for hours, but this is important because if you've got to properly handle the check-in and make sure the authorized voters vote, You have to disqualify ballots if you don't see the authorized voter voting. Once you start opening them, you might have to disqualify ballots, so it's serious, but it has to be in the presence of all of the owners. Jeff, that was a great question. You cannot go in like a back room and do this and say, oh, surprise, we have everything done. That's not how it's handled.
Okay, thanks for clarifying.
More voting and counting ballots. Did I skip one? No, I think I'm good. In our bylaws, it states that proxy voting is not permitted for the election of directors. Can you explain this? So for condos, the statute says you cannot vote by proxy. It has to be by the absentee ballot double envelope system. For a homeowners association, elections are conducted in accordance with the procedures of your governing documents. The statute says, everybody has the right to vote by proxy unless provided in your documents. So many HOAs have amended their documents to eliminate proxy voting and to go with some kind of absentee ballot system. I think it would be, very difficult or maybe improper if they got rid of, any absentee method that they said you have to come to the meeting and vote in person. I've seen that once and I questioned it, but typically it's going to be proxy or some kind of absentee ballot system. Second bullet point, HOAs. Can the holder of a proxy vote in the election for the owner who's assigned the proxy? So for HOAs, proxy voting is quite typical unless you have some other absentee method, and you will generally designate somebody to vote for you in their discretion. Generally, it's going to be some kind of general proxy, which you're then assigning to somebody else and say, hey, Betty, I'm going to give you my proxy. You go to the meeting and you vote for the candidates who nominate themselves from the floor, and you vote for the best 3 candidates. I mean, you can try to tell Betty who you think is going to nominate themselves if they've been politicking in the community, and ask her to vote for who you request. But if it's a general proxy form, that can be voted at the discretion of the proxy holder. Are voting certificates mandated for an annual election? If owners are husband and wife, do they still need a voting certificate? So what is a voting certificate? A voting certificate is something different than a proxy. It is not a proxy. A voting certificate is used, it's a requirement of governing documents only. They're not required by a statute. And what they are is a document used to notify the association of who is authorized to vote for a unit, either owned by multiple individuals or by a corporation. So this is a governing document specific type issue for both condos, co-ops, and HOAs. They're not mandated by a statute. They could be mandated by your documents, and they are very unique. I have to review this very frequently when I'm helping associations prepare for an election or a vote. Is it that they're required when they're owned by multiple individuals? Maybe. Are they required for corporations? Maybe. Are they required for trusts? Maybe. It just gets very specific to your documents, so you got to look at your documents there. Voting and counting ballots. So this is some questions we received on Zoom. Quite a few questions on Zoom.
Yes.
Absentee, yeah, and I don't blame people. That comes up all the time, and it's such a great tool for us to use. I am loving these hybrid, half virtual, half live meetings. I think they get a lot more participation than you would. For those of you who asked a while back, what if we can't get a board elected? I mean, maybe you have the opportunity to use Zoom as a tool to increase your participation, at least as a hybrid method, and in addition to what you regularly do.
Yeah, I've experienced, in fact, with you a couple of times, Allison, we've experienced with the laptop being pointed at the folks counting the votes and being on the Zoom call for, like you said before, a few hours. So we've experienced this a couple of times as well.
So do absentee ballots count towards meeting quorum? This isn't really a Zoom issue yet, but absentee ballots don't count towards a quorum. Once again, for a condo association, you don't need a quorum. The ballots, you need 20% of the membership to cast a ballot. For a homeowners association, no, absentee ballots don't count towards a quorum unless your documents say they do. So it's a governing document type thing, but a lot of times for a homeowners association meeting, you're going to need a proxy. So don't forget about that. Sometimes you can't conduct any business without your quorum there, in which case you would probably want to get a proxy. Does Zoom count for quorum? Yes, if your board has established and if your board has voted to authorize participation by Zoom and voting per Zoom, yes, your Zoom attendance will count towards a quorum. Can you cast your ballot via Zoom? For a condo co-op association, no, you cannot cast your ballot via Zoom. You need the double envelope system. There's just no way to do this. You would have to send it in advance of some kind of hybrid meeting. In a homeowners association, if you are not required to have a absentee secret ballot, if you just have balloting, yes, you can cast a ballot via Zoom. You can cast a vote via Zoom for an HOA election if you do not have some requirement for a secret ballot. In a hybrid and electronic annual meeting, what does this say? Does it count towards do owners count as a quorum that are on the Zoom? Yes, they do. If the board has authorized this and you have some kind of procedure to make sure that you are, accounting properly, right? You got to actually figure out who the people are, make sure that they really are who they are, that they're on the meeting. So you can do this, different ways. But make sure you keep good records of all of this stuff if you are going to allow Zoom attendance to count towards quorum. Keep your login list, keep records. You need to have all of that stuff in case people want to make requests, they want to challenge your vote. You have to make sure that they can follow the bouncing ball and all the numbers make sense. So do it with caution, actually.
Yeah, I wanted to just quickly piggyback on that. One of our questions submitted during registration, that if an HOA board does hold a hybrid meeting, they don't specify whether it's an election meeting or just a general board meeting, but must it afford the Zoom attendees the same opportunity to address agenda items, which in this case would be for elections, remotely via Zoom? And I would assume, yes, you must explain how the attendee will be interacting with the meeting, correct? If it comes time to Q&A and that kind of a thing.
I mean, I think you might be able to say that the Zoom is for viewing only and that you're not authorizing participation and voting by Zoom. If
Okay.
you choose to do that, I think should be part of your board resolution in establishing, use of the system. But I wouldn't recommend that. I would recommend that a board allow people to speak on an agenda item via Zoom. It's not really helpful otherwise. But I think, if you have a very large membership and I think I somewhat think it's fair that if you say, if you want to view only in your own home, fine. If you want to speak on agenda items and actually vote, come to the meeting. I think that would be legit, although I don't know if it's very nice or I would recommend it.
Okay.
Do HOA elections also need envelopes at the meeting? Do Allison's comments about verifying outer envelopes also apply to HOAs? If you have an HOA with secret ballot, secret absentee ballots, you do need to have envelopes available at the meeting, and it's my opinion. There's no statute that says that. It's not as detailed as the condo law, but I would definitely have the envelopes there at the meeting. Verifying the outer envelopes that come in. There's no impartial election committee, but yes, it's the same process where either the board, the manager, some committee designated by the board per your documents is going to sit there and compare the information on the outer envelope, the signature, the lot number, to your list of voters and make sure that they're authorized. And if they're not, they're going to write disregarded on the envelope and put it to the side. So in that type of capacity, in that scope, yes, they are the same. Vacancies. I told you, Jeff, we would get there, and we have some time left to talk about this. Good. On a board of 5, if 3 directors resign, must the remaining 2 fill the vacated 3 seats? So you need a quorum of 3 to operate. We know this, right? And 2 out of the 3 people would have to approve action. So if you feel that you could operate with 3 and, maybe your election is upcoming and it would be just too disruptive to fill the vacancies, yes, you can still operate. But you got to have 3 people at your meeting every single time. If you don't think you can get 3 people there, then I would caution you in running in this manner. The better course is to elect people or to fill the vacancies. You don't want to run with a bare minimum quorum because it just makes it hard to operate. Your fiduciary duty is to operate the association and not, just sit there and not do anything. So you need to be able to have a number of board members to do that. If there are 2 vacant seats for an HOA, are they filled by anyone who submits their name and qualifies and receives votes? I think we talked about this last time. If you have vacancies, who gets to fill the vacancy? Do people get to submit a notice of intent? Do people get to write you an email and say, put me on the board, and you have to listen to their demands? Vacancies will be filled by the remaining board members in their discretion unless otherwise provided in your documents. So most documents are silent on this. Most documents just say the remaining board members fill the vacancies. So the remaining board members typically don't have to fill the vacancy with like the next highest vote getter in the election that just occurred, or whoever has submitted their name, or whoever has requested it, or the head of the finance committee. It's a board purview issue unless your bylaws provide otherwise. If a director was elected for a 1-year term, could the board allow that person to resign and immediately reappoint that person to a vacated 2-year seat in order to have that person stand for reelection? I think yes. I think that could happen. There's a lot of different maneuvering that can occur with election issues for associations. Like, frankly, some of the stuff gets pretty interesting when things like this 3rd bullet point happen and where you kind of shuffle seats. But some of this stuff isn't really, they're legal loopholes, really. I mean, I think that would be okay as long as it was put forward in the proper order and procedurally valid. So yes, I do think that would stand. A lot of times you'll see that you have a very popular board member, stand for re-election. That board member, this is something a little different but similar, that board member gets elected and then in week 1 resigns, and then you have the other board members fill his seat with their buddy. Is that the right thing? Maybe, you could debate that, but it is okay. I mean, it's technically okay. Last bullet point, does the appointment of a new board member to fill a vacancy have to take place during a board meeting at which a quorum is lacking due to the vacancy, or can it take place outside the meeting? I think this is the same question that we had at the beginning, Jeff, where filling a vacancy should be on an agenda. A lot of times we'll have consideration of replacement director, on a board meeting notice, because yes, it does have to take place at a board meeting, and at a minimum, it needs to be ratified at a board meeting. You're going to need the minutes of this meeting to maybe go to your bank and change bank cards, or be a signer on some document. So you need to be able to have it at a meeting, so you have minutes of it, so you can back up some of your board action. That's the real important reason for it.
And you did cover this earlier about how to remove a board member for somebody behind in assessments and such, but does the same process hold true? I know the answer to this, but this just popped up just to clarify. When you want to remove a board member who was appointed and not elected, is the process the same for removing that type of a board member, somebody who was appointed?
Yeah, the process is the same for removing the board member, but just to clarify here, that you can always, remove somebody from their officer position. So a board cannot remove a board member, but a board can meet to rearrange officer positions. So if you have somebody elected at your organizational meeting, which is our next slide, as president, in January, and then by March the person is a nightmare and a dictator, right? That never happens. And the board can convene a meeting with an agenda consideration of reassignment of re-election of officers. And that happens, and then you remove that person from their president position and you put them in as a director. So that is something that the board can do on its own without membership approval. The organizational meeting is occurring after the election. That's where you first are going to elect your officers or conduct some kind of business, such as, policies, who's the check signers, how much maybe the person who's there for season can spend without going to the full board for approval, a couple $100 for this or that. So this is where you set up your policies. I like these meetings. Sometimes it's difficult to do right after the election because frankly, all the board members aren't there. Like they might be spread out. They might have, in a condo, you don't have to be there to accept a nomination from the floor. So you might not be at the meeting. Is there a time frame that an organizational meeting must be held following the annual meeting? While it doesn't have to occur that night for various reasons, it should occur, typically I see in bylaws 10 days, a 10-day period, and you need it to occur pretty quickly because as I mentioned, you need to get your officer positions assigned so you can properly take action in your capacity as that officer. You can get on bank cards, you can get on as, signing for your loan, you can do different things, but you have to be able to back it up. So that means you have to hold the meeting. This meeting is a board meeting. It needs to have a notice. It needs to have a 48-hour notice. So you have to post it, in advance. If you're going to try to have it that night of the election, you must have posted it 48 hours before that. It's a board meeting. Does it have to be a separate meeting or can the officers be elected during a board meeting? It doesn't have to be a separate meeting. If you want to just have a regular board meeting, 2 days late, 3 days later after your election, you could notice a board meeting and have an agenda item, election of officers and treat it as the board's organizational meeting. So you can kind of do both at once. I don't think you need to have two separate meetings. You can incorporate them together. I'm okay with that. Does a new board member need to retake a board certification course if they previously were on the board and took the course? This is a good question. The law actually does address this. So you behooves you to take board certification courses yearly. As you've heard me harp, the laws change, they're constantly changing, hard to keep up. So something that you heard last year might not be the same this year. But no, if you have served on the board without interruption, you don't have to take a new board certification course. If you stepped off the board for a day, for a year, and then you get back on the board, you do need to take the course. It has to be you have to take it within 90 days of your election or appointment, or you can sign the acknowledgement form that you agreed to uphold your duties. Obviously, I recommend taking the course. We offer them pretty much on a monthly basis for condos and homeowners associations. I like to do the courses. Somehow I always do the condo ones. I'm not on the schedule, but I'm sure I will be on there. If you go to our website, you can see all of our courses on the calendar. And health. The last slide sort of deals with what are we doing? What do we do? What are we having election problems? I think you need to plan properly. As I mentioned, get with your lawyer now. If you're questioning what your election process is after last week, after today, get with your lawyer, figure out, particularly for HOAs, what is the process? Do we follow the condo style? Do we follow some kind of nomination from the floor? Are we allowed to have a notice of intent? These are issues that come up all the time. You want to get it right in advance. For a homeowners association, if you don't like your election procedure, amend your documents. The condo style election works. If you want to incorporate it into your bylaws, talk to your lawyer. We've done that many times over the past few years. Clients really like it. Management companies really like it. It's easy to follow. I would recommend that you amend your documents there. Also, get to your lawyer now if you want them to attend your annual meeting. If you're having your meeting in late November and December, get to your lawyer now so they can schedule you and they can be there. If you're having a contentious election or you have a large membership, you've historically had election problems, You want to make sure that they're available, that they are not already scheduled some other meeting that day. So we go to so many of these meetings. If you need a lawyer at your meeting, contact us now. So help, what are the questions? What state, other than lawyers, what state department do we go to validate any changes to our condo docs that we made, I believe, took place in our rules? I believe we made the change since our original documents in 1982, but no one can find a record of this. So apparently you changed the number of directors that were serving in some amendment to your document. This is another amendment that we do all the time. If you don't want to have 7 people serving on your board, if you want to go to a 5-member board and have 2-year terms, you have to do an amendment to your bylaws. And this is apparently what happened here. Usually you would get the document, some kind of title search, public record, official record search, but it might have not been recorded. So if you're a homeowners association, you can have unrecorded documents. If you're a condo association, this needs to be recorded in a public record somewhere. If you cannot find it in the public record, then it is not valid. It is not effective, and you need to vote on a new amendment and get it recorded to get your document to where you want to be. Help. Also, realize if you are in a situation where you're unit owners or you're an association who wants to have somebody oversee your election, if your lawyer is already busy because you didn't contact them soon enough, although we always have people who can help here, you can petition the Florida Condominium Ombudsman to appoint an election monitor for your election. This requires 15% of the total voting interest in your association or 6 owners, whatever is greater, to file a petition, and then you send the petition with the signatures to the Florida Condominium Ombudsman. You can Google this, you can go on the Florida Divisions of Condominiums website, and the Ombudsman will appoint a monitor to come out to your election that day to oversee the process. You have to do this in advance. The association has to pay the fee, but this is an option for those of you, mainly unit owners, who feel that you need some guidance, somebody impartial to come out there, that you don't have access to the lawyer, you don't have resources. This could be something that may help you in that position. With that, we are at the end of the Q&A presentation. I am very happy that we got to do this. I think we took care of a lot of the common misperceptions that I hear over and over again, and some of these issues that are very important and could get to you before election season.
Excuse me. That's great stuff. And we have a few more minutes on the advertised time. And I know we mentioned earlier that today wasn't really for new questions, even though we had the Q&A feature open. We have a few, so please no more new ones. Maybe we can do a quick rapid fire on some of the shorter ones before we head off. Is that okay with you? You want to go through them?
I'm ready.
This one is pretty interesting.
Quiz, right?
Yeah, well, I'll make it as quick as possible here. This is interesting. You just covered the board certification class, which is not only great for new board members, but like Allison said, we think you should take it often because things change quite often. It's a great refresher course, and we offer them for free. If our documents say board members must take the certification course each year, are they still required if the statute says otherwise? So I'm assuming this person's HOA or association has it written in there that they have to take it every year. What do you think about that?
No, I don't think that would be legit, although I wish it would be, because it's beneficial that, eligibility is eligibility. The statute provides for the eligibility requirements for board members, and I'm not sure you can create additional requirements in your bylaws. That has not been upheld in the cases to date, and I don't think that's valid. I will say there is already a bill filed in Tallahassee regarding board certification courses, requiring them in eliminating the option to have the form. So we'll see what happens with that bill. Of course, we'll be communicating with you on that.
Okay. And I'm sticking with questions on elections, not anything else. So forgive me if I skip over some of these questions here. If the elections usually are held in January. Here's an example. Usually held in January, but due to COVID, the last time it was held in April. Does that mean the elections next time will be April or back to January?
I think it needs to go back to January because during COVID, during emergency powers, there were a little more leeway in these things. But even so, even then, you have to comply with your documents concerning the date of the meeting, and therefore you would go back and can start doing it properly again.
Okay. And
It
this one's
does kind of
interesting.
cut off people's terms. I can see that that's where this is headed, but I
Yeah.
think it is what it is in this case.
It's one of those cross those bridges when we get to it types of COVID was.
Exactly.
Yeah.
That
Somebody
doesn't
had
mean
posted,
that would be considered an improper amendment to your bylaws to just change the date because, you did it once and therefore we're on that schedule. No, you got to comply
right,
with your documents, go back and start doing it properly.
right. That was more or less an emergency powers thing just to be able to get it done so the board can run the safety of the community.
Mm-hmm.
Somebody had posed a comment earlier, which is interesting to me because you mentioned favoritism, getting a buddy on the board, that kind of a thing, solicitation, listing of candidates. Should it be done in alphabetical order? So that because the thought process there is you put the one that you want last because that's the last thing people read, the last thing people will remember. So
Oh,
should these
really?
things
I
be
didn't
done
know
in
that would be the strategy there. But in a
from a
condo
marketing standpoint? You put the
in a
last thing.
condo and a co-op, that's not allowed. You have to list candidates in alphabetical order by last name. So in a
Okay.
condo or co-op, no, you'll get your election invalidated. That's a quick way to do so. In a homeowners association, there is really no rule on this. Your documents might address it, unlikely. So theoretically, you could list them in whatever manner you wanted to.
Okay.
Or a homeowners association.
For an HOA.
Unless your documents say something specific. Let's do a
Okay.
couple more.
Yeah, we'll do two quick ones here. This one relatively straightforward. Can a CAM, this is with regards to when you were talking about a CAM being on the election committee, can a CAM be removed / replaced by the board of directors? And I think the CAM works for the board, no?
Well, I mean, that's a little complicated because does your CAM work for a management company? If, then you might have to ask the management company to reassign somebody. If the CAM is your direct employee and you don't have any employment contract, it's an at-will state and, they can be terminated for without cause. But this gets into issues I, probably just can't address at this moment.
Okay. And then here's one that we have a board member who is on the certificate of occupancy, but not an owner. Is this person eligible to run for the board?
Good question for the last question. All members are eligible, and your documents can restrict eligibility to members only, but a lot of documents don't. A lot of documents either don't address it or say that, you don't have to be a member. So this actually is a document related issue for both for condos, co-ops, and homeowners association. It's a very typical issue that people don't look at, and they'll bring it to my attention and say, we didn't realize you don't have to be an owner to be on the board. We need a document amendment. We want owners to be on the board only. So we tend to see that in amendments a lot of the time because developers don't really care when they write the documents.
Okay, gotcha. Well, thanks for covering that. Do you have any, before I do a little ending housekeeping and announcements, do you have anything else that I may have missed that you wanted to address on
No,
there?
just reiterate again, make sure you get these notices correct. You don't want to have to, have egg on your face and have to send out some revised or supplemented notice. Get to your lawyer now with any election related questions. Get your election on their calendar if you want us to be there and you have a complicated or contentious election. I wish everybody the best this season. Look forward to seeing you soon.
That's great. And Allison, last thing, what's the best way for people to reach you if they need assistance for their associations?
If you want to reach me, send me an email. I'm on email all the time, like all of us. If you want a consultation, you have specific questions related to your association, please reach out with an email and we'll be in contact with you as we can.